With the 1990 census, the state legislature were faced with drawing their states to create the electoral district boundaries in the United States to better fit the changes in population, also known as redistricting.
"12 seconds later.
In North Carolina, the state legislature submitted their map with one majority-minority black district that was very strange in shape in order to encompass a large black population. In reality, this is how the district was shaped, as shown in yellow on this map of North Carolina.
Perfect.
However, this map was rejected by
Hey.
U.S. Attorney General Janet Reno.
Hey, there's something clearly wrong with this. You need one more.
A second majority-minority district could have been made to further improve representation of black voters. The state revised and submitted a new plan, which had two black majority districts, one of which had parts that were no wider than the interstate road that it encompassed.
Objection!
The appellants, 5 North Carolina residents including Ruth O. Shaw, however, claimed that this was an unconstitutional racial gerrymander and that it was created solely for the purpose of assuring the election of 2 black representatives to Congress, which is in violation of the Equal Protection Clause. The Equal Protection Clause is part of the 14th Amendment and states no state shall deny to any person within its jurisdiction the equal protection of the laws. The district courts utilized the legal precedent of Inc. v. Carey, which stated that apportionment plans can be used to attempt to prevent racial minorities from being repeatedly outvoted at the expense of the white populations, to rule that the appellants failed to state a constitutional claim. However, the case was appealed all the way up to the Supreme Court, where it was granted certiorari. The Supreme Court disagreed with the district court and decided that the redistricting was in conflict with the Equal Protection Clause. Justice O'Connor described that racial gerrymandering reinforces the perception that members of the same racial group, regardless of their age, education, economic status, or the community in which they live, think alike, share the same political interests, and will prefer the same candidates at the polls. We have rejected such perceptions elsewhere as impermissible racial stereotypes. Simply put, appearance does matter when it comes to redistricting, and the court found that such districts such as that in North Carolina is so bizarre on its face that it is unexplainable on grounds other than race. In the end, the court held in a 5-4 decision that redistricting based on race must be held to a standard of strict scrutiny under the Equal Protection Clause, and those doing redistricting must be aware of the Voting Rights Act of 1965, which prohibits racial discrimination in voting when dealing with race.